are here today to debate Bill C-27, the Digital Charter Implementation Act. With this bill, the government seeks to bring Canada's consumer privacy protections up to date, create a tribunal to impose penalties on those who violate those protections, and create a new framework on artificial intelligence and data. For my constituents, I think the most important question is, why are consumer privacy rights important? Well, your personal information has become a commodity in the modern world. Businesses and organizations regularly buy, sell, and transfer your personal data, such as your name, your gender, your address, your religion, what you do on the internet, your browsing history, your viewing and purchasing habits, and more. This happens so often that it's almost impossible to know who has access to your sensitive data and what they do with those personal details. Unfortunately, Madam Speaker, this bill fails to adequately protect the privacy of Canadians and often puts the commercial interests ahead of privacy rights. The first part of this bill is the Consumer Privacy Protection Act, and I will note, as many others have during this debate, that it is really 3 bills in one. It is the largest part of this bill and brings in a new regulation on the collection, use, and sale of the private data of Canadians. I will cover 3 issues, as I have found in this Act, related to the first part of this bill. The first issue relates to how organizations may collect or use your information without your consent. Subsection 18, paragraph 3 states, an organization may collect or use an individual's personal information without their knowledge or consent if the collection or use is made for the purpose of an activity in which the organization has a legitimate interest that outweighs any potential adverse effect on the individual resulting from the collection or use and of that data. Without defining what a legitimate interest is, this clause risks giving organizations free rein to define legitimate interest in whatever way suits their own commercial interests. The second issue I'll cover relates to how the bill would protect the privacy rights of children. Subsection 2, paragraph 2 states, for the purposes of this Act, the personal information of minors is considered to be sensitive information. However, nowhere in this bill are the terms minor or sensitive information defined. This will lead to confusion about how personal information of children should be handled and ultimately lead to, in my opinion, weak protection of that information. There is also no other provision in this legislation that regulates the collection and use of children's personal data. Now, any parent in this House of Commons is very concerned about their child going on Minecraft, their interaction with other people, other gaming sites. This bill doesn't do enough to protect children in the context of online gaming and protecting them. The last issue I will raise on this Act relates to when organizations can rely on implied consent to collect and use personal data. Subsection 15, paragraph 5 states, consent must be expressly obtained unless, subject to subsection 6, it is appropriate to rely on an individual's implied consent, taking into account the reasonable expectations of the individual and the sensitivity of the personal information that is to be collected, used, or disclosed. Madam Speaker, this subsection again highlights the use that this bill lacks a clear definition of sensitive information. This means that organizations will have free rein to determine when they can rely on your implied consent, and they will be free to decide what information is or is not deemed sensitive according to their interpretations and not the legislation's. The second part of the bill relates to personal information and data protection and the creation of a new tribunal act. This second part of the bill, would create a new semi-judicial body with the power to levy financial penalties against those who would violate the CPPA, or the first part of the Act. I question whether this tribunal will be able to enforce the penalties outlined in Section 128, which are tied to global revenue and a proportion of profit in a previous fiscal year. How does the government plan on ensuring accurate figures? How does the government really believe that they're going to go after Google in the global context and hold Google accountable and collect possibly up to 4 to 5% of Google's global revenue. It's farcical. We need very clear and very big amendments to this section, and we need to even question whether we need a tribunal, because if it's in charge of enforcing Section 128 of the bill, I know it's already going to fail. Under the third section of the bill, the Artificial Intelligence and Data Act, new provisions are created that apply to the private sector. However, this bill does nothing to address the relationship between government and artificial intelligence. Right now in Parliament, we're debating Bill C-11, which talks about the government's use of algorithms in the context of CRTC. This bill has rightly infuriated Canadians across this country who are concerned about how the government will determine what you say and do on the internet and where you will be directed. Why isn't the government trying to apply the same standards upon itself as it's trying to apply on private corporations? Now, I want to address some other key oversights in this bill. In the UK, EU, and even Quebec, certain personal details such as race, sexuality, and religion are given special protection in comparison with other personal information. Why does this government believe the most identifiable aspects of our personal information are not worthy of being defined as sensitive information in the context of privacy law? Secondly, the bill does nothing to regulate the sale of personal data. I'm just reiterating this point. In a world where the sale of personal data has become an integral part of our economy, why isn't this government concerned with setting clear rules on how and what kind of data can be bought and sold, especially in the context of children? Third point, the bill fails to regulate the use of facial recognition technology. The RCMP used Clearview's AI facial recognition database, which was illegally created. Why does this government not think it is appropriate to ensure this never happens again? Fourth, the Consumer Privacy and Protection Act and the Personal Information and Data Protection Tribunal Act proposed in this bill are nearly identical to the aspects proposed under last Parliament's Bill C-11. The consequence, Canada's consumer privacy laws will be out of date by the time they even come into force. So this bill, Madam Speaker, was an opportunity to put forward strong regulations on the collection and use of personal data, but failed to meet some basic criteria and thresholds. While the increased penalties for violating the Act are welcome, they are watered down by the implementation of a tribunal that will take months, potentially even years, to make a decision and levy fines, and it's even questionable whether such a tribunal could actually do what it's purported to be responsible for. Do we really need privacy legislation that fails to protect the privacy of Canadians? Do we really want privacy legislation that fails to put consumer interests ahead of corporate interests? Do we really want privacy legislation that fails to protect the personal information of children? And do we really want AI regulations that don't apply to government? Frankly, Madam Speaker, this government needs to withdraw Bill C-27, break it up into different parts, and come back to Parliament after they've looked at the drawing board again and done something a little more comprehensive. Thank you, Madam Speaker.
You know, it's interesting that the deeper we get into the debate, the deeper the Conservative Party gets into disliking the legislation. And for me, I look at the legislation as something that is going to have a very strong positive impact in protecting the privacy of Canadians. It has penalties that are going to be put in, substantial financial penalties, even though the member opposite mocks those penalties, Madam Speaker. There's issues such as the privacy management programs that businesses are going to have to put forward. There's so much good stuff in this legislation, and yet the Conservative Party is prepared to say, we don't care. We have other things that we have on our agenda. We are going to prevent this legislation from passing. Madam Speaker, my question is, does the member not feel that Canadians deserve this kind of legislation, at least as a starting point, and the Conservatives can do whatever they would like afterwards?
Why bring forward legislation that doesn't define sensitive information in the context of children? We all know this is a problem. I acknowledge this is a problem. Why not do the work right now? There's a lot of very talented public servants that can define sensitive information in the context of children. Related to Section 128 and the fines imposed for people that would break the Privacy Act, the ability of the government of Canada to go after global tech companies and asking them to pay the government of Canada a portion of their earnings from a previous fiscal year, like, the government of Canada is just not capable of doing that right now. So it's fluff. It's absolute fluff, Madam Speaker.
Thank you, Madam Speaker. I was curious to know what my colleague thought about the apps that involve games or quizzes and so on, but are really looking for personal information and contact information, cell phone numbers, and so on. Does he think the bill should also legislate around that? That's a very important point. For a parent like me with a 7-year-old son, he's just starting to play games on his iPhone or something like that. So this is not a situation that's covered by this bill. So we can't say that this bill is going to protect children, because the definition of sensitive data, there is no definition in this bill, and we need one.
I think what's unfortunate with the Conservative position here, they've raised some significant problems with the bill, although stopping it for going to committee is rather ironic, because the suggestion is to hand this entire project back to the Liberals and their central party organization and their political infrastructure, and to start over, as opposed to moving this to public debate, witnesses' testimony, and expert dialogue that's necessary. And I'm not willing to turn this entire project back to the Liberal machine. And I think that's what's unfortunate here. And I can attest to the member that his members in the committee are actually very good members. So I'm looking forward, and we've heard speeches from Conservatives saying that they want amendments. Why won't they actually bring it to committee then and get it to amendments? I think that's a better choice than turning it back to the Liberals to whenever that's going to take place.
I will note that the member from Windsor West, I'm on industry committee with him, and he provides a lot of intelligent insight and corporate knowledge to key pieces of legislation just like this one. Unfortunately, we're in a situation today where the New Democratic Party has decided to support the Government of Canada on all key pieces of legislation. So even if the member from Windsor West has a problem with a key aspect of the bill, I am not confident that the supply agreement between those two parties will result in good legislation. And that is why the Conservatives are calling on the Government of Canada to go back to the drawing board, because at the end of the day, the New Democrats don't have enough money to fund a federal election, and that's why they're supporting the Liberals despite this poor legislation. Thank you, Madam Speaker.